All right. As of late, the topic has been about banking, so we're going to go into negotiable instruments. And I'm going to try and keep these videos nice, short, and sweet. To start out, we need to understand what the Negotiable Instrument Act is, where it derived from, how it's been integrated in the United States, as well as throughout the world of commerce. Okay. And so we're going to start out regarding the historical background of the Philippine Negotiable Instruments Act, Act number 2031. There are four things to remember: the U.S. Uniform Negotiable Instruments Act, the U.S. Uniform Commercial Code, the precedent NIL in the Philippines, and the Code of Commerce. U.S. Uniform Negotiable Instrument Act, our law, is patterned with very slight modifications after the Uniform Negotiable Instrument Act of the United States of 1896, drafted by the National Conference of Commissioners on Uniform State Laws. The conference was appointed in 1895 to revise and codify the law merchant in the United States, as there was much confusion and lack of uniformity then in the court decisions on the subjects, resulting from the variety of statutes pertaining to commercial paper enacted by various state legislators. This law, in turn, is based upon a largely copied from the English Bill of Exchange Act of 1882, a codification of the laws in England governing bills of exchange, promissory notes, and checks. Most state legislators adopted the act as the main law for regulating commercial paper. Now, what's important about that is in all 50 state constitutions, we have what is known as the law of the motherland, okay? And if you go and study all 50 state constitutions, you will see in there where every last one of them has adopted the common law of England or the laws of England. And that's known as the law of the motherland. Okay, so when you're speaking about negotiable instruments, what I'm going to take you to next is we're going to go into the Canada Bill of Exchange Act. Because when we get into the United States of America, you're going to find that most of it is found in the UCC, and I don't want to be hopping around all day long. In the UCC, I want to show you the Bill of Exchange Act so you can understand the UCC a little bit better. If you understand where the UCC derived its language from, then perhaps it will help you understand the UCC better, okay? Which stands for the Uniform Commercial Code. So, let's start out by what's negotiable and what's non-negotiable. Title 49 U.S. Code, subsection 80-103, negotiable and non-negotiable bills. Negotiable bills. A bill of lading is negotiable if the bill states that the goods are to be delivered to the order of a consignee, and B, does not contain on its face an agreement with the shipper that the bill is not negotiable. Okay, so if it states that it's not negotiable, it's not negotiable. Ladies and gentlemen, if you have your birth certificate handy, go ahead and look at that, because that, in fact, is a bill of lading. And if you'll notice on it, nowhere on there does it say that it is non-negotiable. 2, inserting in a negotiable bill of lading the name of a person to be notified of the arrival of the goods does not limit its negotiability, and B, is not notice to the purchasers of the goods of a right the named person has to the goods. B, non-negotiable bills. 1, a bill of lading is non-negotiable if the bill states that the goods are to be delivered to a consignee. The endorsement of a non-negotiable bill does not A, make the bill negotiable, or B, give the transferee any additional right. 2, a common courier issuing a non-negotiable bill of lading must put non-negotiable or not negotiable. On the bill, this paragraph does not apply to an informal memorandum of acknowledgement. Now we're going to get into the Negotiable Instruments Act. And let's see. We'll go through the whole damn thing. Fuck it. Short title, interpretation, definitions. In this act, definitions are always going to be your most important part to start with. You always want to pay attention to the definitions because this is where you're going to be able to find your standing, okay, and your comprehension of what you're doing. Acceptance means an acceptance completed by delivery or notification. Okay, so a notification or a delivery is considered in law an acceptance. Okay, action includes counterclaim and set off. Okay, that's what an action is. An action is either a counterclaim or a set off. Bank means a bank or an authorized foreign bank within the meaning of Section 2 of the Bank Act. Now, this Bank Act thing is out of Canada. So, bearer means the person in possession of a bill or note that is payable to bearer. This is so important. Write down payable to bearer. This is where a lot of your vouchers, a lot of your coupons, that's what they're going to say. Pay to bearer, okay? Bill means bill of exchange, also known as a, oh, that's in French, never mind. Bill means bill of exchange, okay? So if you're getting a coupon and it states that it's a bill, all right, then it means it's a bill of exchange, ladies and gentlemen. Defense includes counterclaim. Delivery means transfer of possession, actual or constructive, from one person to another. That's what delivery means. Endorsement with an E means an endorsement completed by delivery. And holder means the payee or endorsee of a bill or note who is in possession of it or the bearer thereof. All right? Issue means the first delivery of a bill or a note. That's what an issue is. An issue is the first delivery of a bill or a note, complete in form, to a person who takes it as a holder. Non-business days means days directed by this act to be observed as legal holidays or non-judicial days, and any other day is a business day. Note means promissory note. Okay, so a note is a promissory note. A bill is a bill of exchange. Value means valuable consideration. All right. Part 1, general. Things done in good faith. So important. Write this down. We are always doing things in good faith. In good faith, with good conscience, for good reason. Okay, with clean hands. Done in good faith, with good conscience, for good reason, with clean hands. A thing is deemed to be done in good faith within the meaning of this act, where it is, in fact, done honestly, whether it is done negligently or not. You see why we do things in good faith? Because under 40 statute at large, 411, anything done or omitted in good faith is not a jailable offense. We're always acting in good faith. We're never wishing to defraud or scheme or cause harm, damage, or loss to anybody. We're always doing things in good faith, with good conscience, for good reason, with clean hands, to remain in honor. Signature, where by this act, any instrument or writing is required to be signed by any person. It is not necessary that he should sign it with his own hand, but it is sufficient if his signature is written thereon by some other person by or under his authority. What's funny about this statement here, ladies and gentlemen, on the signature, is when you get a payment coupon or a voucher, So often, if you'll read it, it says include the check with the coupon. What you don't realize is you have an account with the other financial institution that you've been doing business with. All right. And they have a presumed power of attorney. So when you're sending them a check or a money order plus the payment coupon or voucher, they're getting paid twice. Why? Because they have the authority under the Bill of Exchange Act to go ahead and endorse that on your behalf to them. All right? And that's what they're doing. They're double dipping because we are ignorant and don't know the law. So let me read signature again to you so you really understand this power of the payment voucher and coupon. Signature, where by this act, any instrument or writing is required to be signed by any person, it is not necessary that he should sign it with his own hand, but it is sufficient if his signature is written thereon by some other person by or under his authority. Guess what? Every financial institution you've ever given an application to automatically presumes and assumes to have a power of attorney to do things on your behalf. All right? What required of corporations? 5. In the case of a corporation where, by this act, any instrument or writing is required to be signed, it is sufficient if the instrument or writing is duly sealed with the corporate seal, your thumbprint, but nothing in this section shall be construed as requiring the bill or note of a corporation to be under seal. Okay? Your right thumbprint is the one and only in the world. All right? You've been given a great seal, and you can seal all your documents with your right thumbprint. You can put a seal on there. Computation of time. 6.1. Where, by this act, the time limited for doing any act or thing is less than 3 days. That's commercial law, ladies and gentlemen. You get something in the mail, don't shirk your responsibility, open it up, have a gander at it, endorse it properly, mail it out right away. Make sure that you include a stamp on it and follow the Tax Stamp Act, okay? Because all negotiable instruments must have a stamp on them. The Tax Stamp Act has never been repealed. In reckoning time, non-business days are excluded. That's a 72-hour period to be in honor, to remain in honor. Saturdays. In all matters relating to bills or notes, remember bills are bills of exchange, notes are promissory notes. If the time for doing any act or thing expires or falls on a Saturday, that time is deemed to expire on or fall, as the case may be, on the next following business day. B. A bill or note payable on demand cannot be duly presented for acceptance or payment on a Saturday, and C. Failure to do any act or thing on a Sunday does not give rise to any rights. Okay? So very important. We want to be timely. Remember, freedom is about accountability, responsibility, and liability. We got 72 hours from the time it's delivered to our humble abode to take care of business. And it's really not that hard. It's a pen and a piece of paper, ladies and gentlemen. It's really simple shit. Checks. 3. Notwithstanding any other provision of this act, a check may be presented and paid on a Saturday or a non-judicial day if the drawee is open for business at the time of the presentment, and the presentment in all other respects is in accordance with this act, and the non-acceptance or non-payment of a check so presented gives rise to the same rights as though it had been presented on a business day other than a Saturday. Where bank not open for business. 4. In all matters relating to bills or notes, bills being bills of exchange, notes being promissory notes, notwithstanding any other provision of this act, if a branch of a bank carrying on business is not open for business on a business day, A, The time for doing any act or thing at the branch, if the time expires or falls on that day, is deemed to expire or fall, as the case may be, on the next following business day on which the branch is open for business. B. A bill or note, a bill of exchange or a promissory note payable on demand cannot be duly presented for acceptance or payment at the branch on that day. And C. Failure to do any act or thing by reason of the branch not being open for business on that day does not give rise to any rights. All right? What they're saying there is, by showing up on a day that the branch is closed, you can't say, well, I showed up, I made an offering, a tendering of payment, and nobody received it, so an offering, a tendering of payment made and refused liberates the debtor, and I'm out of here. All right? That's what they're telling you. You got to provide grace, due process of law. Crossing dividend warrants. The provision of this act relating to crossed checks apply to a warrant for payment of dividend. Bank Act not affected. Nothing in this act affects the provisions of the Bank Act. Common law of England. Remember, if you're in the United States, this is the adoption of the law of the motherland, okay? And those rules absolutely apply here in the United States because the United States was never free from Britain. It's a joke. It never happened. The rules of the common law of England, including the law merchant, save insofar as they are inconsistent with the express provisions of this act, apply to bills of exchange, notes, promissory notes, and checks. Protest evidence. 10. A protest of any bill or note within Canada and the United States, and any copy thereof as copied by the notary or justice of the peace, is in any action evidence of presentation and dishonor, and also of service of notice of the presentation and dishonor as stated in the protest or copy of protest evidence. Where a bill of exchange or a promissory note presented for acceptance or payable outside of Canada is protested for non-acceptance or non-payment, a notarial copy of the protest and of the notice of dishonor and a notarial certificate of service of the notice shall be received in all courts as evidence of the protest, notice, and service. Officer of bank not to act as notary. Okay, so when you're signing a mortgage, a promissory note in a bank, and you're doing business with that bank, it's a conflict of interest to have one of the employees be the notary and sign off on it because they are being paid by that bank. And a lot of times your mortgages and your promissory notes and stuff that are signed in banks, the agent and agency that is the acting notary at the time is currently gainfully employed and on the clock for the bank. And that creates a conflict of interest. No clerk, teller, or agent of any bank shall act as a notary in the protesting of any bill or note payable at the bank or at any of the branches of the bank in which he is employed. Purchase of patent right. This is so important. We get the given for a patent right out of the Canadian Coinage Act, all right? And I like to put this on my negotiable instruments. I like to put this on my bills of exchange, given for a patent right, all right? And I also like to write for collection, given for a patent right, for collection. Purchase of patent right. Every bill or note, every bill of exchange or promissory note, the consideration of which consists in whole or in part of the purchase money of a patent right or of a partial interest, limited geographically or otherwise, in a patent right, shall have written or printed prominently and legibly across the face thereof, before it is issued, the words given for a patent right. All right. Now, again, I'm using the law of the mother country and I'm adopting it to my bills of exchange, my promissory notes. I'm always putting given for a patent right because why? My intellectual property is on that promissory note. My intellectual property is on that bill of exchange. Okay. My life source energy went into it. My life source energy is a valued time commodity. It's a taxable event. Okay? Absence of necessary words. If the words given for a patent right are not written or printed on any instrument in the manner prescribed in subsection 1, the instrument and any renewal thereof is void. You think given for a patent right's important? I think it's important, because the instrument and any renewal thereof is void without it, except in the hands of a holder in due course, without notice of the consideration. Given for a patent right is where you're giving the consideration, ladies and gentlemen. Transferee to take with equities. The endorsee or other transferees of any instrument referred to in Section 13 having the words given for a patent right printed or written thereon takes the instrument subject to any defense or set off in respect of the whole or any part thereof that would have existed between the original parties. Let's see if I can blow this up for you guys there. There we go. All right. That's number 14. Okay. Number 15. Offense and punishment. Every person who issues, sells, or transfers by endorsement or delivery any instrument referred to in this section in Section 13 not having the words given for a patent right printed or written across the face thereof in the manner prescribed by that section, knowing the consideration of that instrument to have consisted in whole or in part of the purchase money of a patent right or of a partial interest, limited geographically or otherwise, in a patent right, is guilty of an indictable offense and liable to imprisonment for any term not exceeding 1 year, or to such fine not exceeding $200 as the court thinks fit. Bills of Exchange Part 2. Form and interpretation of bills. Bill of Exchange, 16.1. A bill of exchange is an unconditional order in writing, addressed by one person to another, signed by the one person giving it, requiring the person to whom it is addressed to pay, on demand or at a fixed or determinable future time, a sum certain. Write that down. The sum certain is very important. Sum certain makes the instrument also negotiable, in money, to or to the order of a specified person or to bearer. To bearer is important. To the order of a specified person is important. Sum certain in money is important. Okay? Non-compliance with requisites. An instrument that does not comply with the requirements of subsection 1 or that orders any act to be done in addition to the payment of money is not, except as hereinafter provided, a bill. All right? An instrument that does not comply with the requirements of subsection 1, this right here, is not a bill of exchange. We like bills of exchange, ladies and gentlemen. A lot of your vouchers and coupons are actually bills of exchange. Okay, they're not promissory notes. They're bills of exchange. They're dividends checks. You just don't realize it yet. Well, I'm going to drill it into your guys' head by the time I'm done with all this. Okay, so we want to be compliant with subsection 1. All right. Unconditional order. An order to pay out of a particular fund is not unconditional within the meaning of this section, except that an unqualified order to pay coupled with an indication of a particular fund out of which the drawee, which is always the guy that's the payee, he's the payor, is to reimburse himself or a particular account to be debited with the amount, or B, a statement of the transaction that gives rise to the bill of exchange, is unconditional. Okay? So your light bill. You got your interest up front, ladies and gentlemen. You got your interest up front. You got your electricity up front. You never had to do anything to get your electricity up front. Then they send you a bill with a payment coupon attached to it. Okay. And now all you need to do is endorse that payment coupon and send it back. You're gonna do an acceptance, not accepted. It's not past tense. You're gonna do an acceptance, okay? And then you're going to go ahead and put given for a patent right, and you're gonna fill that puppy out just like a check. Now, for any of you at home right now, all you have to do if you're listening is go find your last electricity bill, wastewater and heat bill, whatever it is, pull it out, and I guarantee you there's a coupon or a voucher at the bottom. And if you look at that son of a bitch, you'll go, son of a bitch, it's a check. Because it is. It's a check. All right. It's not just a check. Excuse me. It's a negotiable instrument. Okay. It is a bill of exchange. It's got an account number on it. It's got routing numbers on it. It's just waiting for you to do an acceptance, to flip it over, to endorse it properly, put your right thumbprint on it, and send that puppy back in the mail in a timely manner. Instrument payable on contingency. 17.1. An instrument expressed to be payable on a contingency is not a bill of exchange, and the happening of the event does not cure the defect. Addressed to two or more drawees. 2. A bill may be addressed to two or more drawees, whether they are partners or not, but an order addressed to two drawees in the alternative or to two or more drawees in succession is not a bill of exchange. So if you're not the only one on the instrument, guess what? It's not a bill of exchange anymore. Okay? Payee, drawer, or drawee. 18.1. A bill may be drawn payable to or to the order of the drawer, or it may be drawn payable to or to the order of the drawee. Now, on your instrument, if you got a wastewater electric bill or a heating and air bill, and you pull that up, they'll tell you who to make it payable to. And that's all you got to do. Because the maxim of law states this: he who provides the ends provides the means. And when you filled out your original application, ladies and gentlemen, you granted them access to your trust. Necessite by trust, okay? And it exists. It's there. That's how this whole system works. Two or more payees. 2. A bill may be made payable to two or more payees jointly, or it may be made payable in the alternative to one of two or one or some of several payees. 3. Holder of office payee. A bill may be made payable to the holder of an office for the time being. Now, check this out. They're giving you the instructions right on the payment coupon, right on the voucher. You have the instructions, I guarantee it. They're on that document somewhere. First, you have the statement, and then you have down at the bottom is where it's perforated, and you can tear it off just like a check or a coupon or a voucher. It'll have the account number. It'll have the routing number. If it doesn't have the accounting number, ladies and gentlemen, it is important that you go track down the accounting number and write it on that instrument, okay? Because it needs to have the accounting number and the routing number on it in order for them to be able to process it, okay? In most instances, it has all that. Now, if it doesn't have the account number, give that local financial institution that you're doing business with a call and tell them you need the account number, and they'll give it to you. Don't go doing all this cockamamie horse shit, cracker shit, where you just start adding zeros and your social security number to things. Don't do shit like that. The law is specific, and it's written in fucking black and white, and I'm reading it to you. Drawee to be named. The drawee must be named or otherwise indicated in a bill with reasonable certainty. Transferor words. 20, number 1. When a bill contains words prohibiting transfer or indicating an intention that it should not be transferable, it is valid as between the parties thereto, but it is not negotiable. So when you make it so it's non-transferable, non-negotiable, ladies and gentlemen, that's kind of like a special deposit. If you're making a promissory note to a private individual saying that it's non-negotiable, non-transferable, that means they can't go to the bank. That means as soon as you settle up with them in whatever manner you decided to contract with them, whether it's Federal Reserve notes, chickens, goats, whatever it may be, ladies and gentlemen, you're entitled to your note back. If they can't give you your note back, then they owe you all the payments back. Okay? If it's non-negotiable, non-transferable, that means that it's private between two parties, and that's it. When it's negotiable, it means it can be sold and traded and thrown into the stock market, and Lord knows where it'll end up. And when you pay it off, you may have paid the wrong individual, and because of that fact, they could come back and foreclose on you later. All right, and I've seen it done. I've seen it happen in quite a few mortgage cases, as a matter of fact. Negotiable bill. A negotiable bill may be payable either to order or to bearer. Negotiable instruments are either to order or to bearer, paid to the order of, put the company name there, or paid to the bearer, and you can just leave it at that. You don't have to go any further. With bearer paper, whoever's holding the bearer paper is the one that is right to redeem it. And there's only one stipulation to bearer paper, is if anybody calls into question how they ascertained it, they have to prove how they acquired it. That's it. With bearer paper, it's nice. So paid to the bearer is a really nice way of doing it. If you're worried about it getting lost in the mail or somebody stealing it, then put paid to the order and be specific of who you're paying to the order of. Okay? When payable to bearer, a bill is payable to bearer that is expressed to be so payable, or on which the only or last endorsement is an endorsement in blank. An endorsement in blank is an unrestricted endorsement, ladies and gentlemen. Certainty of payee. Where a bill is not payable to bearer, the payee must be named or otherwise indicated therein with reasonable certainty. All right, so if you're going to put pay to the order of, you can't put ABC Bank. You need to put, American Cartel Bank. All right, you got to spell it all out. Don't abbreviate. Be very clear with what you're doing when you're doing pay to the order of. Bearer paper is a little bit different. Fictitious payee. 5. Where the payee is a fictitious or non-existing person, the bill may be treated as payable to bearer. All right. Bill payable to order. 21(1). A bill is payable to order that is expressed to be so payable, or that is expressed to be payable to a particular person and does not contain words prohibiting transfer or indicate an intention that it should not be transferable. All right. When payable to person or order. 2. Where a bill, either originally or by endorsement, is expressed to be payable to the order of a specified person and not to him or his order, it is nevertheless payable to him or his order at his option. When payable on demand. 22. 1. A bill is payable on demand, A, that is expressed to be payable on demand or on presentation. So it's either on presentation or on demand. These words are going to be very important to you later on when you start learning how to draw, because you're a preferred stockholder in the United States. You're a creditor. You're an investor in the United States. You have special drawing rights. Okay, and I'll show that to you guys later on. But you have special drawing rights, and these words are going to become very important because when you're drawing a security that is the security obligation of the United States, ladies and gentlemen, it has to have a curing rate of that is cured in 90 days plus 3 days grace, and nothing exceeding 90 days. Okay? And I'll explain all that later. Or B, in which no time for payment is expressed. So when payable on demand, a bill is payable on demand that is expressed to be payable on demand or on presentation, or in which no time for payment is expressed. Endorsed when overdue. 2. Where a bill is accepted or endorsed when it is overdue, it shall, with respect to the acceptor who so accepts it, or any endorser who so endorses it, be deemed a bill payable on demand. Determinable future time. 23. A bill is payable at a determinable future time within the meaning of this act that is expressed to be payable at sight or at a fixed period after date or sight. Or B, on or at a fixed period after the occurrence of a specified event that is certain to happen, though the time of the happening is uncertain. Inland bill. 24. An inland bill is a bill that is, or on the face of it purports to be, A, both drawn and payable within Canada, or B, drawn within Canada on a person resident in Canada. Foreign bill. 2. Any other bill is a foreign bill. Presumption. 3. Unless the contrary appears on the face of the bill, the holder may treat it as an inland bill. All right, and those same rules apply in the United States of America as well, just so you're aware of that. When we come back, we're going to venture on, I believe that was the short title, interpretations. We'll get to we'll go to form and interpretation when we come back. All right. So we'll get to, I think we just covered that, didn't we? Bill of exchange, payable, order, endorsed when overdue. Yep, we just covered that. So when we come back, we'll be at acceptance. All right. And this is important stuff. I want to help each and every one of you. I have been blessed by a plethora of ingenious SOBs that have surrounded me and have continued to nurture me for all these years, 13 plus years now. They are savants. They are brilliant. And I want to be able to help you guys out the same way that they have helped me. And so when we come back, we'll be talking about acceptances. We're going to help you guys understand this so you can get rid of the guru shit out of your fucking ears and start doing things the right way. And we start out by doing things the right way by knowing that we're going to be making sure that our endorsement states given for a patent right, for collection, done in good faith with good conscience, for good reason, with clean hands. We're completely making sure that everybody knows that our intent is honorable and that we're here to do the right thing. And when you start negotiating these instruments, I want you to understand something very clearly. For the last 50 to 60 years, nobody's been doing this properly, okay? Or very few have been doing this properly. And because of that, many of the people that work in these financial institutions are going to think that you've done, the fucking cheese is fucking slid off your cracker. I want you to just get prepared for that now. They're going to think that the fucking cheese has done slid off your cracker and that you're fucking nuttier than squirrel shit. Be prepared for it. But I'm showing you the law, all right? Now, this is the law of the motherland. For those of you in the United States, we'll be getting into the UCC a little bit later, but we're going to go first through the Bill of Exchange Act, the Negotiable Instruments Act of 1882. Then later on, we'll go into the International Bill of Exchange Act, the International Promissory Note, and I'm going to show you guys how you can convert all your instruments, because remember, you can't pay for shit. You're just tendering for offset and discharge. All they're doing is they're holding your credits, and all you have to do is release those credits. And the proof of that is, for those of you that are thinking about this going, what the fuck is this guy talking about? Let me fill you in. How many of you have ever gotten an overdraft bank account? Okay. So we understand when you get an overdraft bank account, what is the number that is represented on the slip? Well, if you overdraft by 50 bucks, it's a negative 50. If you overdraft by 100 bucks, it's a negative 100, right? Okay. The vouchers that are being sent to you are in a positive form. And mathematically speaking, you cannot pay down a positive number. Okay. If you add a positive number to another positive number, you increase that number. So let's say the payment voucher is for $50 and then you send them $50. Well, you just took that $50 that was positive in the account and you now made it $100, 100 credits on account. Okay. So once you start to gain the concept of this, it's very, very simple. It's very easy. And our objective is always to bring the account balance to zero. Zero is the most beautiful number in the world. It's perfect in every way, shape, and form. All right. When we come back, we'll be dealing with acceptances. All right.